And if the mountain should crumble or disappear into the sea, not a tear, no, not I. Oh, hello. Hi. Mr. Morris here to help you start studying for the Unit 6 exam, the Judicial Branch. What you need for this video is a printout of Article 3 that looks like this. If you got it from me in class, on the back it has a copy of excerpts from Federalist Paper number 78. And hopefully you will have already read it and tried to answer the questions, and therefore I'm just sort of helping you fill in maybe a couple blanks that you missed. Otherwise, stop the video right now, read this over, try the questions, and come back again. Okay, let's start with Article 3 of the Constitution. As you will recall, Article 1 describes the powers of Congress, Article 2 describes the powers of the Chief Executive, the President. Article 3 describes the function and the powers of the Judicial Branch. The very first words, the judicial power shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The only court mentioned by name in the Constitution is the Supreme Court. Inferior courts refer to any other courts that Congress may create below the Supreme Court. If you have this chart, you'll see that the Supreme Court's at the top, and that all the other courts that kind of feed in to the Supreme Court are considered to be inferior courts. They are not named in the Constitution, but it does give Congress the power to create those courts, which they have done so over time. It also does not establish how many justices will serve on the Supreme Court. That also is left up to Congress. Nowadays, it's supposed to be 9. Tell that to the Senate. And it has been 9 for, I don't know, 150 years or so. It has varied from 6 to 8. Eventually we settled on 9 because it's an odd number, which helps because the Supreme Court decides cases by voting, and an odd number reduces the number of ties. The second question on that piece of paper, explain the meaning and effect of the sentence beginning, the judges. I'm going to go ahead and show you this, and if you can tell in green the words that I have highlighted. Judges shall hold their offices during good behavior. The meaning and effect of that sentence is this. Whereas the other branches officials, members of the House, members of the Senate, and the President, they are given power for a specific period of time called a term. The judges in the Judicial Branch are not given a term of office. They hold their jobs during good behavior, which means as long as they do their jobs, possibly until life. That's sometimes the way people put it. They hold their jobs for life. What's the importance of that is it puts them beyond the control, to a certain degree, of the other two branches. The other members of the other branch have to worry about the people's opinion of them. They have to run for re-election. They have to earn their jobs over and over again. But the members of the Judicial Branch do not. Once they are appointed by the President, confirmed by the Senate, they are free to do their jobs without worrying what the people or what the other branches think about them and how they're doing their jobs. This grants them a huge degree of independence. Because of that phrase, the good behavior clause of the Article 3, we have an independent of the other two branches, a fully independent third judicial branch of our government. Really, really important phrase in the Constitution. To emphasize it even further, that sentence continues, and shall at stated times receive for their services a compensation, that's in orange. That's what I've highlighted in orange. A compensation which shall not be diminished during their continuance in office. Congress has the power of the purse, so Congress has the power to set judicial salaries. However, that line in the Constitution specifically prohibits Congress from trying to influence judicial decisions by reducing judges' salaries. Let's say the Supreme Court issues a decision that Congress doesn't like. The Supreme Court declares a law Congress has passed unconstitutional. Congress can't punish the court by reducing their salaries because it's in the Constitution. So please, please, please understand how important those phrases are to our entire system of government. Let's move on to Section 2. The question there, after you read that paragraph, Section 2, the question is, describe all the ways the federal judicial power is limited here. Now, you might be thinking, but wait a minute. In line after line after line, the Constitution is telling us what powers do the courts have. And my question is, how is power being limited here? And the answer is, it's being limited by this list of powers, because whatever is not on the list, guess what? Federal courts can't handle those issues. So, exactly what issues can they get themselves involved in? The judicial power shall extend to all cases. That might not mean much to you, but listen to this. That statement says that judges can only issue opinions regarding actual disputes that come before them, actual real-life cases, not in any other circumstance. What other circumstance might judges like to offer their opinions? Well, what about a hypothetical situation? What if the president's thinking about doing something, or Congress is about to pass a law, and what if the Supreme Court could sort of say, hey, that thing you're about to do, that's unconstitutional? The Constitution doesn't allow them to do that. And plus, early on in our history, they specifically refused to do that. That actually reduces the court's power, because they would have more power if they could just give their opinion before the other branches have done something. This says they can't do anything until after the other branches have done something. What other ways does this limit the powers of the courts? They can only handle cases regarding the Constitution, laws of the United States, that's federal laws passed by Congress, and treaties made under the Constitution. So they can only handle cases that regard the Constitution, federal laws, or treaties. Guess what kind of cases they can't handle? Cases, at least not initially, cases involving state law, questions of state law. And then it gives a long list of the kind of cases that they can handle in terms of the parties involved. The parties involving ambassadors and other public ministers, maritime jurisdiction, controversy to which the United States shall be a party. What that means is if one of the two people in the case, so-and-so versus so-and-so, if one of them is the United States government, so the U.S. versus Nixon, for example, that's the United States is one of the parties in the case, so that kind of case will be heard in a federal court. Controversies between two or more states, so if Maryland sues Virginia, that controversy, that issue, that case will be heard in federal court. And the list of other things there, but basically the lesson from that paragraph is that paragraph does grant the Supreme Court and other federal courts significant amount of powers, but it also, if you pay attention, the flip side is that anything not on the list, they can't do. So it also limits their powers. And remember, when we wrote the Constitution, we were very concerned to create a government that was limited in its powers. 4, explain why this is important. All right, jurisdiction, first of all. What is the term jurisdiction? Jurisdiction is the power to hear a case. Maryland courts have jurisdiction over issues of Maryland law. Virginia courts have jurisdiction over issues regarding Virginia law. Federal courts, according to this paragraph, only have jurisdiction over cases having to do with the Constitution, federal law, or treaties, or cases with certain parties involved. So jurisdiction means the power to hear a certain kind of case. And this paragraph definitely sets the jurisdiction in writing of federal courts. The next paragraph, in all cases affecting ambassadors, blah, 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 and those in which states shall be a party, the Supreme Court shall have original jurisdiction. And then the other cases, it shall have appellate jurisdiction. Now what's the difference? Original jurisdiction is the power to hear a case first. And what that means is to hold the actual trial. When you think of a trial, what do you picture? You picture the defendant, prosecution, for the plaintiff, you see a jury, you see the lawyers involved, you see witnesses, you see evidence being presented. That's a trial. Trials happen at courts with original jurisdiction. Appellate jurisdiction means a court can only hear appeals from lower courts. So let's say this is how it works. So I'm caught breaking a federal law. My trial is held in a court with original jurisdiction. Let's say I lose, and I think there's something wrong with the trial or with the law that I broke. So I appeal to what we say it this way, it's a higher court. It's technically an appellate court or an appeals court that reviews the decision of the lower court where the trial was held. So back to this diagram. This layer or level of federal courts right here are the courts with original jurisdiction. That's where trials are held in the federal court system. Courts above at this level, and including the Supreme Court, those are courts with appellate jurisdiction. They hear appeals, they don't hold trials. Although that paragraph does tell you that on occasion, it's very rare, on occasion the Supreme Court can actually hold a trial. It's very rare, maybe 2 or 3 a year. Because not many cases come to the Supreme Court under its original jurisdiction. Almost all the court cases that come to the Supreme Court come to it through its appellate jurisdiction. Next paragraph, next sentence, next question. Who has the authority to define or change the Supreme Court's appellate jurisdiction? Clearly that paragraph says Congress can alter the Supreme Court's appellate jurisdiction. Number 7 and 8, reading the next paragraph. What important individual right is protected in the next paragraph? The trial of all crimes, except in cases of impeachment, shall be by jury. There you go. You are guaranteed a jury trial. If it's a federal criminal offense, you are guaranteed a jury trial in a federal court. Number 8, why trials must be held in the same state where the crime was committed. This is actually an interesting kind of check and balance, but in terms of federalism. If I commit a federal crime, let's say in Maryland, the trial has to happen in federal court, but it has to happen somewhere in Maryland. What that means is the jury would also have to be composed of people who come from Maryland. And that one reason that was specified in the Constitution was just in case the federal government gets too powerful and starts passing laws that people don't really want, and then you're accused of breaking one of those laws. Well, the jury is one of your own people, and the jury could just very well say, "Oh, you're innocent," to contradict what the federal government wants to happen. It's kind of a check and a balance between the two levels. Section 3 defines treason. You don't have to remember the specific definition of treason, but it's interesting that there is a definition of treason, and the reason why, number 9, explain why the Constitution includes this definition of treason. It's the only crime mentioned in the Constitution. The reason it's in there is because when we were subjects of England, frequently the king and or parliament would change the definition of treason so that a certain enemy of the government could be executed, because usually the penalty for treason is death. It's the definition of treason is put in the Constitution so that can't happen. So that it makes the definition of treason fixed and can't be changed just so the government can try to put to death somebody who just wants to. Number 10, identify the major power of the judicial branch that does not seem to be mentioned anywhere. Well, I hope you noticed. I hope you were looking for it while you were reading Article 3, and I hope you noticed it wasn't even there. And the specific power, major power of the judicial branch that doesn't really even seem to be mentioned anywhere is the power of judicial review. the power to declare laws passed by Congress or acts of the President unconstitutional. Not in there anywhere. How come we think the courts have this power? It's because the Supreme Court claimed to have that power a long time ago, and it stuck. Now, the name of the case was Marbury versus Madison, of course. Now, was the Supreme Court in 1803 the only people in America who thought the court should have that power? No. Remember, there were Federalists and Anti-Federalists. Well, the head of the court at that time was a man named John Marshall. He was very much a Federalist and believed in the authority of the federal government, and he understood that the authority of the federal government relied on a very strong, powerful judicial branch. And he authored the decision in Marbury versus Madison in 1803 with that in mind. He thought that the courts needed to have this power, or the judicial branch was simply this little third weakling that couldn't do anything, and he knew that would hurt the federal government's power going into the future, so he made sure that when he got the chance, he claimed to have that power. Now, on the back of this piece of paper, I have excerpts from Federalist number 78. Now, this was written 15 years, I think, before the Marbury decision, but it gives you evidence that there were other Federalists at the time who just took it for granted that the courts should have that power. This was written by Alexander Hamilton. And if you read especially the bolded areas, I think you can pretty easily answer the questions I'm asking. What does Hamilton say about the power of the courts compared to the power of the other branches? Well, he clearly says that the judicial power is the weakest of the three branches. The Congress has the power of the purse, the executive branch has the power of the sword, and the only power that the judicial branch has, which has neither force nor will, their only power is the power of judgment. They can only say what's right and what's wrong, but they can't enforce it. They don't have money, and they don't have weapons or an army or whatever. They can't even force the other branches to carry out their decisions. So clearly, the third branch, the judicial branch, is the weakest of the three. What's the relationship between judges and the Constitution? If you read that, I think pretty clearly he realizes the judges are the defenders of the Constitution. They explain the Constitution to the other branches and to the people. They have to protect the Constitution as fundamental law above all else. And he realizes that sometimes the other branches aren't going to like that. Sometimes the people aren't going to like that, but it's the job of judges to do that. Lastly, what ultimate power should the courts have? The power of judicial review. He doesn't use those words, but he does say to the power to void laws if there's an irreconcilable difference between them and the Constitution. Please read this if it didn't make any sense the first time. That's it. The next video I post is going to be starting on the Unit 6 study guide. I'm not going to be able to do it myself. I'm going to have somebody else stand in and do it for me. Look for me to post that video very soon. Bye-bye.